I was questioning a world-class surgeon during his pretrial deposition, and find out why. After 30 minutes of questioning him, I said to the defense attorney, I have no more questions. Want to know what happened? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, my client brought a lawsuit against this world-class neurosurgeon, right? He claimed that the doctor violated the basic standards of medical care, causing significant harm and injury. And now, I was not the attorney who participated in starting this lawsuit. I happen to have inherited this particular case. So now when I took over the case and reviewed the entire file, I thought, okay, this sounds interesting. This is a very interesting case. We have a qualified medical expert who supports our claim, and his violation from the standard of care was a cause of your injury. And your injuries were in fact significant and permanent. So now, as I'm preparing to question the doctor during his pretrial deposition, which is really nothing more than a question and answer session that takes place in his attorney's conference room. The attorney for the doctor is there, I will be there, the doctor will be there, but there's no judge there, there's no jury there. But all of my questions and all of the doctor's answers get recorded by a court reporter, also known as a court stenographer. And all of that information gets transcribed and put into a booklet called the transcript. During my brief period of time that I was questioning this neurosurgeon, I knew immediately that this doctor did absolutely nothing wrong. How did I know that? Because I had my expert's opinion that I had reviewed multiple times before. I knew what I needed to ask the doctor to establish whether or not there were violations from the basic standards of medical care. In this particular case, it was obvious to me that this doctor did absolutely nothing to cause or contribute to this patient's injuries. Now, how is that possible? How could the initial attorney not realize that? How could the expert who reviewed these medical records at the beginning of the case not realize it? You want to know how? Because there was information that was missing from the hospital record. You see, this case was primarily triggered because this world-class neurosurgeon did not write any notes in the chart following his treatment of this patient. Yes, he wrote a very detailed operative report when he did a very long surgery on this patient. But when he saw the patient each and every day in post-operative visits, there was not a single note from this doctor explaining that he was there, that he saw the patient, he examined the patient, this is what his findings were. And because there were absolutely no notes referring to the fact that the doctor came and visited his patient, the expert concluded incorrectly that this doctor was absent. He'd gone AWOL, right? Absent without leave. Nobody in the entire hospital, not a resident, not a nurse, nobody ever talked about where this doctor was on any of the days following this patient's surgery. And part of the case involved claims that this doctor abandoned this patient and did not do or recognize that there were problems in the post-operative period. And his failure to recognize or do things post-operatively after his surgery caused and contributed to this patient's injuries. At least that was the theory by our expert at the very beginning of this case. So it turns out that our expert was totally wrong. Now, what actually happened? I learned from this doctor that it was the custom and practice of this doctor and many other doctors at this particular hospital in New York that they do not write their post-operative notes or observations. Why not? Because they have other doctors to do it for them. And this doctor said something interesting. He said, listen, I go on rounds every single day with the residents and with the fellows who are caring for this patient. We examine them together. The resident is the one who goes ahead and makes a note in the chart. And yes, there were notes by the resident throughout the entire stay for this patient. And there were also notes by the fellows, these senior doctors, right? But now, nobody ever refers to this attending doctor, this world-class neurosurgeon being there. And he tells me, listen, it is our practice that we rely on the residents, and if I disagree with something they have written, then and only then will I make an entry in the chart to indicate what the correct course of treatment is or to correct what they've written. Once I learned this information, now it made sense. Now the other notes by the other doctors were consistent with everything that had gone on, and it was clearly obvious to myself and to the defense attorney that this doctor did absolutely nothing wrong. So you know what I did? By the time I got back to my office, I had already dictated a note explaining my rationale, my reasoning for letting this doctor out of this case. And then the next step was I had to call my client and say, listen, here's what went on when I questioned this neurosurgeon who operated on you. And it is my legal opinion that this doctor did absolutely nothing wrong. And just to make 100% sure, I then reached out to my expert to run the scenario by him, and I explained to him, if what he's saying is true, would you agree that he did nothing wrong? And you know what he said? I would agree, which meant I had to let the doctor out of the lawsuit, and we continued on against the hospital. So why do I share this quick information with you? I share it with you just to give you an indication of how, even though we believe that you had a valid basis for a case, once we learned certain information at the doctor's pretrial questioning, it changed the entire case around. You don't realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and are thinking of doing so, what I invite you to do is, you know what I'm going to say, right? Pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.